Initiative for Transparent Strategy and Good Leadership has criticized remarks made by Senate President Godswill Akpabio concerning the ongoing political crisis in Rivers State. Akpabio had referred to Honorable Martin Amehule as the Speaker of the Rivers State House of Assembly and acknowledged 26 others as authentic members, sparking controversy. Akpabio made these comments during a public lecture in Port Harcourt held to celebrate the birthday of the Minister of the Federal Capital Territory, Chief Nyesom Wike. He suggested that if Governor Siminalayi Fubara refuses to cooperate with the Amehule-led assembly, the lawmakers would proceed with their constitutional duties, stating that not even a court could prevent them. Reacting to the statements, ITSGL President General Barrister Chizi Enyi condemned Akpabio's comments as divisive and detrimental to peace in the state. Enyi noted that Akpabio should have remained neutral as Senate President, especially since Amehule and the others had defected from the People's Democratic Party to the All Progressive Congress, which, according to Section 109 of the 1999 Constitution as amended, invalidates their membership in the Assembly. Any questioned Akpabio's reference to actions the lawmakers might take against Governor Fubara that courts could not halt, hinting that the statement likely alludes to impeachment. And he further expressed concerns that Akpabio's comments might escalate political tension in Rivers State, accusing him of attempting to support Wike in leveraging federal power as compensation for Wike's backing of his Senate presidency. Honorable Don, what do you make of this story?
I need to set the record straight. I was in that event that day from the start to the end of the first session.
That's the birthday celebration of the FCT minister.
Exactly. I was inside right just at the first rule, just before the first rule of that program, where the Senate President and the FCT minister sat. I listened to the Senate President. I did not think, and I'm of the view, that the Senate President did not make comments like, if the court is not ready to...
At the court, what was said that Akpabio said that if Amehule-led House of Assembly should, invoke their constitutional powers to when they perform their constitutional duties, that the court cannot even halt them from performing their constitutional duties. And he is saying that that statement alludes to impeaching the governor.
That cannot be correct. That cannot be correct. Of course, the law is clear. The court will not stop a House of Assembly doing the right thing, performing its duty, legitimate duty, from doing it. The court doesn't have that power. The court can only stop a House who is doing something that is not legitimately being done. I hope you understand. The court cannot stop a House of Assembly from doing a legitimate legislative duty. The court doesn't have that power, with all respect. But the court has the power to stop a House of Assembly from doing an illegitimate action that is not known to law. So Akpabio, speaking of saying the court will not stop a House, was saying the court will not stop them from doing what they are supposed to do as a House known to the law. That's what Akpabio was saying. So there are no, and I know there's no, we should not, I hate when people preempt, or I hate when people speculate. And the problem that has gotten us Rivers people to where we are today is emotional speculation. Dead, tainted, ill-mannered emotional speculation. So while he's speculating, he has come up with the opinion that it is divisive, it's going to be divisive, or because he wants to use it as a means to please the FCT minister to continue to hold Senate presidency. That is, in fact, it is not a matter before us now. That is just speculative. So Akpabio didn't say wrong. Akpabio was, as a lawyer, he knows what he was saying. You understand? He was saying what the provisions of the Constitution is. So, as at today, Akpabio also, you know, being a lawyer who has also read the judgment and followed the trend of the whole story, knows that as at today, Chikemati Ameule is the Speaker of the River State House of Assembly. And I've told you here before that in DAPA long against Darie 2008, the Supreme Court have held that on no account shall any insignificant number of a member of House of Assembly legislate or make a resolution on behalf of the entire state, you know, on matters of public importance. That judgment is there. You think the Supreme Court is not guided? They are guided. They are guided. We are not in a banana republic where you choose what you want to do. You pick the banana you want, you run away, you eat it, you come back, you pick, you run away. No. This is not a we are ruled by a body of laws. And so the issue, the matter is, oh, people defected. No problem. People carried flag that you say they defected, you say they carried flag. The issue is, have you been able to prove that there was actual defection? I hope you understand. Proof of actual defection. And I've told you here that a man does not defect from a political party to another. One, there must be a letter of resignation. You understand? Sent to the ward. It is the ward where you belong to your membership. Your register of membership is in the ward where you come from. You must send it to the chairman of the ward, stating that you have defect from today, that they should deregister you, remove your name from the register of members of that ward. And then your name must also be removed. Evidence of this must show. Now, all these issues that happened, where are the affidavits of any of these chairmen as are dead of the ward level that show that these things happened? They could not present it. You remember that they went to Justice Basam's court in Port Harcourt. Even while Basam declined the decision, Basam said certain things. And said, there's nothing before me. So even look, even what I'm seeing, there's nothing even before me. Not to talk about coming to ask me to invoke the decision of this court. No. Do you get it? So that is a nightmare to Okojombo and his group. It will continue to be a nightmare. Because they are always speculative and being too emotional about these things. In law, you remove emotion. See, remove sentiment. Face facts. That's what the court wants. Facts and evidence. The court is not there. Show me what will make me believe that this thing happened. Yes, they carried placard. We saw people carry placard. We saw people said they were televised. See, there is nothing like televised defection. Defection is a procedure. Have you met those conditions? Have you met? I am married. This is my wife. Show us certificate of marriage. Do you get it, Laurentia? Show us. Oh, Laurentia is my wife. Oh, she's my wife. Look at
so in this instance, now, if I may get what you're saying that televised defection does not amount to constitutional, what the Constitution provides as defection. Now, on that's on one hand, and on statutory defection. All right, televised defection does not amount to statutory defection, and it's in this instance the court is not concerned about the televised defection. The court is concerned about proof of defection as provided for by the Constitution.
Well, yes,
the party constitution.
By law, yes.
We have two constitutions here: party constitution and Nigerian constitution.
That's why we said by statutory provisions. Statutory provisions is the law. It can be a small party guideline.
All right.
It can be the constitution of the party, or what. But those provisions that is required, even constitutionally.
So number one, there has to be. Let's slate it the way you stated it. Number one, there has to be a written
written letter
to the ward.
To the ward,
and that letter has to be ratified.
It doesn't. Once you sign it, and then followed by an action deregistering. There is no national membership of PDP or whatever.
Now there has to be deregistering. So when your ex-wild party, when the court assesses their register, your name is not expected to be in your register.
Exactly.
And if they are saying
there must be exhibited of former register, now current.
And current, okay, an exhibit of that. And then the party that the person has defected to, it's expected that the person's name will be in the register.
The person's name will be in the register now.
Interesting. And then, however, Tony Okocha has come out to say that these people are not in the party register.
They are not in the party register. Do you expect him to say they are in the register when they are not in the register? Let them go and show the register now.
Isn't that why Tony Okocha is being, there are allegations that he's working for the FCT minister?
You see, the problem is...
I'm asking you questions that when you look at it critically, it appears, because I also watched that televised defection, and Tony Okocha had a lot to say about
Laurentia, let me tell you, in the history of politics in Rivers State, this is the highest politics that have ever been played. So people are only confused about the new dimension of the politics. That's what is generating all this emotion. I too was also surprised, but I had to go and do my research, and I looked at it, that all this fanfare doesn't amount to what
the law happened was drama.
Was a drama.
Now, on the other hand, there is this issue of affidavit that the lawmakers swore. What do you have to say to that?
Let me tell you. That there is, as I speak to you, there are no affidavit before any court.
Because it has been withdrawn?
Of course, withdrawn, and when the matter was withdrawn, now look at it. They filed a matter before the court. That's Justice, I think Justice, is it Okorowo's court or Abdul Malik? I'm seeing it.
Over what matter?
During the period that these issues was going on. That they, in the one of the affidavit that defection, we on this day we say we no longer be member. You understand that kind of it. Now, when they serve these processes on the other parties, including Okojombo and the likes, they came to court, Federal High Court, Abuja, and they told the court that we have been served with these processes. My lord will wish to respond. Do you understand? The court said, okay, fine, we'll give you date. Now, within the period that they filed and the period hearing was supposed to take place, they brought in a lot of applications. Application to amend, application for change of counsel, application for I had additional witnesses or whatever that they wanted to, So, what am I saying? All these applications did not give room for the court to commence hearing of the substantive suits. I hope you understand. So, as at that point, issues have not been joined. Issues of law and fact had not been joined. Parties were still exchanging processes, so the court had not assumed jurisdiction.
Okay.
Do you understand? So, when the court hadn't assumed jurisdiction, these matters, parties were still transmitting documents. So, Martins Amewule and the 25 lawmakers or 26 lawmakers who initiated the action felt it was no longer necessary because of other matters before the court that also touches on those subject matter, and apply to withdraw the application. They are originating processes. And it is a matter. Will you force them to remain in court? After all, issues have not been joined. They withdrew the affidavit. So what is the, why is it all of a show of animosity that they withdrew the application, that they swore that they defected from this party and all that? I hope you understand. Why? So, see, the public must allow this matter for us as lawyers to look at. They are even part of the problem, because when they share this emotion, sometimes it can kill somebody before you hear from the person. I've not seen a period that is more than this when the judiciary has faced a lot of humiliation, hate speeches, and the like. And then, furthermore, this other issue that has to do with Justice Joy Alumalik's judgment that has to do with the cessation of the public funds and all that.
Yes.
You remember that the Court of Appeal setting aside the orders made by Honorable Justice Joy Adumalik of the Federal High Court, stated that it was a subject matter jurisdiction, hence the matter was set aside because he felt that the court did not have jurisdiction to handle the matter. But if we go to section 251, sub-arrow of that subsection, obviously, I will only crack part of it. And I will be thinking that probably if the court had taken a very deep look at the provisions of that section, you understand, maybe it would have influenced the judgment of the court. Section 251, subsection arrow, provides clearly that, the Federal High Court will have jurisdiction on any action or proceeding for the declaration or injunction affecting the validity, of any executive or administrative action or decision by the federal government or any of its agencies.
But in this instance...
Let me finish.
In this instance, is the matter not bordering on a state allocation?
Can I finish?
Go ahead.
Who gives states allocation?
What was the cross of the matter?
No, I'm asking who
is
gives...
Is it not the budget?
Who gives states of... Who gives...
CB is a federal agency,
Thank
CBN.
You.
However, is the matter
so can you sue CBN in state court?
Is the matter not around the state budget?
What they went to court is court. This thing is not... you people are giving this money. It's because of this money you are giving. That's why these people are continuing to violate the provisions of this constitution. Stop it, because they have not done this and done this. It's the money. It's the money that you are releasing, the things that they are doing, because since the money is coming to them and they are not bothered about following what the law says, stop it. The matter was targeted at the CBN. I hope you understand. The matter was targeted at the CBN. So by this provision, it was not wrong for the plaintiff to have gone to court, bringing CBN, going to the Federal High Court. Maybe the court looked at it with a parochial view. You understand? What in law, close the court with jurisdiction is the reliefs, the cause of action and the relief sought. Do you understand? The cause of action and the relief sought is what the court will look at. So these reliefs that we are sought, are they not part of the issues? The federal government via the Central Bank of Nigeria are the one releasing these allegations. So you would have asked, going to State High Court, give an order that will bind this Central Bank of Nigeria. Okay. So that matter, that judgment, with all respect to your lordship, the judgment, I have a reservation of the judgment.
It was a 2-1.
I don't know what you mean by 2-1.
There were 3 panel of judges in
the
appellate court. It was a 2-1 decision. Okay. 2 was in support that the fact allocation should be paid, while 1 was against. So
obviously, so we have to look at we have to look at the dissenting decision of the court and see whether they can explore appeal. But I still have my reservation on the judgment, because I feel that the court didn't take proper care to look at.
But then,
because I think that was judicial.
But then it is what it is, and considering where we are at in Rivers State, if that fact allocation was stopped, don't you think we would have been in more crisis than we are already? See, that is the problem. We will have been. I am concerned. I'm not concerned. I'm not concerned about the elites. I'm not concerned about the elites. I'm concerned about the people. Obviously, people would have suffered. But why don't we stop that we make the people suffer? Which is what? Which is the inability of the government of Rivers State and the government to follow the provisions of the law, the Constitution. That's what we mean. Why don't you leave this in and do the right thing?
In the eyes of even a moral man, can two person, become a constituted house of, who is the speaker, who is the majority leader, who are the members, who passes these laws? And you know that the Constitution, Section 4 of the Constitution of the Federal Republic and Section 11 of the Constitution makes that every resolution that is made, okay, every law that is to be made by the House will be made by resolution. And the law has stated that 2/3.
All right, very well.
And I have told you on this program that this Section 158 says that the House of Assembly at no time must not be less than. I've given you a number. Must not be less than 20 or 24. Sorry.
24.
Must be,
and the House of Assembly members must not be less than 24 members.
Beautiful. Members are those people elected from their constituencies. Is it not? Okay, beautiful. You think the Constitution did not know what they were doing? They have taken Kano into consideration. They have taken Rivers into consideration. Do you understand? So now, are they not? Is the governor not in breach? You should ask yourself what's delaying the presentation of the 2024 budget.
I was coming to that because that's a question I ask practically everybody that comes on my show. Rivers State's 2025 budget. So as we round up the show, or I move on to the next story, Rivers State 2025 budget. I mean, it's we are a few days away, 13 days or 15 days away from the end of the year 2024 budget. While 2024, sorry, we are a few years end away from the end of 2024 budget because it's a full cycle budget. 14 days or 15 days from now, we'll be in 2025. So is Rivers State going to enter 2025 without an appropriation bill?
That question should be asked. The governor should be meant to answer that question.
Well, I'm asking you.
Am I the governor?
Interestingly, but you have a lot to say about Rivers State crisis, don't you?
Obviously a lot, but
you have a lot to say. So I expect you to also have something to say.
But I choose not to say. I'm not the governor.
You cannot withdraw yourself from speaking. I mean, you've been talking a lot about the budget.
The governor,
you have the opinion that the allocation should have been withheld from Rivers State. You have spoken so much about the governor running without a budget. And now there is a conundrum. Even though the recent appeal court judgment, that will be the second appeal court judgment that is affirming Martin Samehule as the Speaker of Rivers State. The governor, even after the first appeal court judgment, still said he has recognized them. Now, is there going to be a change of heart? Well, that is on one question, on one part. On the other part, is the governor waiting for the Supreme Court judgment to know whether the judgment will go in favor of Martin Samehule or in his favor, and then if it's in his favor, then he can move on to Okojo. But even if it's in his favor, can the governor legislate with four-man assembly? So is Rivers State going to? Yes, Edison Nehie is still a member of Rivers State House of Assembly. Even in the appeal court judgment, the first appeal court judgment recognized Edison Nehie as a member of the Rivers State House of Assembly. I'm looking at the letters of the law, of the judgment, sorry, in this instance. What the judgment, so I speak based on what the appeal court has said in the first appeal court judgment. Now, moving forward, what is the way forward? Even if, let's just say, the Supreme Court gives judgment against Martin Samehule, it means that INEC will have to conduct an election, and until those seats are filled, then legislation cannot happen. Or is the National Assembly now going to take over, and then probably, the budget will be submitted to the National Assembly pending when elections? It's complex at this point. What do you make of it? Are we not at a crossroad in Rivers State?
That's what it appears to be. That's what it appears to be. But for we that are fair-minded, legal-minded, we are not. I don't buy the idea ipso facto. All I want the governor to do, nobody's dragging the governorship with the governor of Rivers State. No. Okay, and the governor must also understand that he steers the ship of state. In steering the ship of state, there are certain things you need to know. Even the Bible says, if you have erred, you go back and ask for forgiveness. God will forgive you. In this case, the governor have made the first mistake by not presenting the budget to the well-constituted House of Assembly. In the light of the judgment, the governor should keep those egos, dissemble those fans that are trying to, confuse him, and do the right thing. If the governor I'm sure that the governor also has remorse. I am of the view, I have this thinking that on some selling moments, I think that he also has remorse. But the way they have played this whole thing appears to make the issue look as if it's not something that can be resolved. I bet
so you think
this
is a function of ego now playing out?
Ego and selfish, cheap interests of those people who are fully benefiting from the part of the governor. That's on the side of the governor. So
now you're saying that the people advising the governor do not want this crisis to end?
They wouldn't, because they are benefiting from it.
If the crisis ends, they cease to benefit from
Obviously.
it. That's what that's your opinion. So now, since it is, according to you, if it is what it is at this point, then does that mean that we are not going to, the governor will not present the 2025 budget? Is he going to wait for Supreme Court judgments? And the moment we enter January 1, 2025, it will count against him, won't it?
I think, they are looking at, I think there's some part of the constitution that the governor is thinking that may be to his favor, but
the one that there is a pause where he can spend from pending when the constitution, the budget is passed and all of that. But that can work if he's already operating with a budget.
That can work. It's not even.
Is that going to apply in this instance?
No. Every budget is a full cycle budget.
Yes.
And expires to 30th of December.
Mm-hmm.
Obviously, the law expects that before the expiration, that must be presented.
3 months to the expiration of the budget.
Before the expiration of that year. Mm-hmm. That's what the law says. Not 3 months. That year. That will present a new budget.
The law, actually, go and check it out. Because when there was a time the National Assembly called out the president.
Not 3 months. Before the end of the fiscal year.
That's what I'm saying. When the National
That's
Assembly,
why I see some governors are doing.
It was discussed on my show.
Yeah.
And I had to go and do my research.
I can open it for you.
That when the National Assembly was calling out, they were telling the president that usually they had 3 months, and that is past 3 months to the end of that fiscal year, and the presidency is yet to present a budget. If that is not correct, what does the law say? The law
says before the end of that fiscal year. Section 162, you can look at it.
All right, go ahead. Go ahead, continue.
So, well, I'm not the governor of River State, so I don't know why he has not.
You are trying to avoid this conversation.
Why he has not? Why he has not presented a budget? I'm not the director of budget that prepares budget for the government. So I don't know why he's still waiting. Why he has not presented the budget? Maybe he's thinking of which of the House of Assembly, which of the faction that wants to present the budget to. That's my belief. I think he's confused of which of the aspect of the faction of the government that the house that wants to present the budget to.
All right, very well. Unfortunately, we are out of time because I would have loved to delve into this section 122. But from the overview, what I'm seeing here is he's talking about federation accounts, distribution of funds, and revenue definition. These are the 3 things that
162.
under. Yes. So 162, I opened it. That's where I'm on right
Check
now.
161 then.
I don't have time for that.
All right.
So probably in the next conversation I'm going to have with you, we'll bring it out. Definitely. All right. Thank you so much.
But before I go,
Yes.
This is a Yolita season, and I want to believe that we will allow peace to reign even in this Yolita season. The governor of Rivers State should continue to remember that what he owes us is the welfare and security of the state, and whatever action that people take, it will obviously impact on the lives and properties of the state. We must be guided by what we do. And for those that are fans to the actors, we must be guided by what we do, what we say, and know that we have just one River State. But overall, Your Excellency, in all sincere mindset and thinking, I want to call on you to continue, make sure we continue to keep the peace and do the right thing.
All right.
We can't vote you and hate you. That's the truth.
All right, Honorable.